Right out of the gate, this case is already intense. The mother's bond violation list reads like a toxic cocktail: cocaine, meth, amphetamines, and alcohol. It's rare for all these substances to show up together, and this sets the tone for what the judge's patience is about to look like. Razor-thin.
Petitioner's 33 indicates that in August of 2023, mother tested positive as a violation of her bond for cocaine, methamphetamine, amphetamine, and alcohol, correct?
That's what I understand. Yes.
Right, and
Attorney Seidel or Attorney Broussard, would either of you like to make an opening statement at this time?
no, Your Honor, I'll call my client when I get started.
Okay. And then Ms. Geyer, would you like to make an opening statement?
No, ma'am.
Okay. Attorney Seidel, you may call your first witness.
Thank you. I'll call John Rotan.
Okay.
Mr. Rotan, you're the petitioner in this case, correct?
Yes, sir.
Okay, and we're here about Mason, who is 9 years old today, correct?
Yes.
In May of 2021, we entered an agreed order in the case, and Mason was 5 years old, and we appointed both parents joint managing conservators with equal possession schedule, no child support, and mother was not to consume any alcohol during her periods of possession, correct?
Yes, sir.
And the alcohol issue was, at that time, mother was on probation for a misdemeanor DWI out of Dallas County, correct?
Yes, sir.
And additionally, she had been arrested and was on bond for a felony DWI out of Denton County for felony DWI of driving intoxicated with a child in the car, correct?
Correct.
And the child in that case was Mason, correct?
Yes. Yes, sir.
Okay, and so she had conditions of bond that prohibited from using alcohol, correct?
Yes.
All right. We went forward then on the petition to modify.
This is where things turn emotionally heavy. The father isn't just fighting for custody, he's describing a terrified 9-year-old refusing to visit his own mom. When a child starts showing that level of fear and anxiety, family courts take notice. It's not just hearsay. It's a red flag waving in the judge's face.
In October of 2021, correct?
Yes.
And you attached an affidavit to that petition, and in it you expressed to the court concerns. First of all, Mason was expressing a great deal of anxiety and refusing to go see his mother, correct?
Correct.
And you were concerned, he had made statements to you that made you concerned about possible sexual abuse, correct?
Correct.
All right. And additionally, you indicated that shortly before we filed, there was an incident where mother called you highly intoxicated and you went to her house, correct?
Correct.
And Mason was in her care along with an infant child that she had had since then with another man, correct?
Yeah.
And at that time, she was highly intoxicated. This was shortly before October of 2021, correct?
Correct.
You had to take care of the infant while she was intoxicated, and you went about 10 p.m. and stayed till 1 a.m., correct?
Correct.
How quickly the timeline stacks up here. The court keeps giving the mother chances. First with Burlink, then with pet testing, then counseling. But every time, she fails or refuses. At this point, the courtroom isn't debating if she relapsed. It's how many times.
And at that time, when mother woke up from being asleep, she told you she needed help with her alcohol problem and needed to get her life together, correct?
Correct.
And she allowed you to take Mason and keep him, correct?
Correct.
And so we went to court on that. On a temporary orders hearing was held October 28th of 2021. And those rulings are reflected in petitioners 3, correct?
Correct.
Mother was ordered to go on SoberLink and take a PEth test, correct?
Correct.
And because she had testified, she had not consumed any alcohol because that's part of her conditions of bond and her probation, correct?
Yes, sir.
And that she did take the PEth test as court ordered and she failed the PEth test, correct?
Correct.
All right. The judge then entered further temporary orders reflected on petitioner's Exhibit 4 in December of 2021 because we had SoberLink violations at that time by mother, correct?
Correct.
All the SoberLink records are admitted as petitioners 14, correct?
Correct.
Additionally, at that time in our hearing on further temporary orders in December of 2021, there was another positive PEth test by mother, correct?
Correct.
Okay. At that time, the associate judge ordered no overnights for mother and restricted her time, limited her time each week, correct?
Yes, sir.
And the judge ordered that you could supervise those visits at your discretion. Mom was ordered not to drive the child, and mother was ordered to be evaluated and treated by the Nexus Recovery Alcohol Center, correct?
Right.
Okay. We came back to the court in March of 2022 with an emergency motion, correct?
Correct.
That was based on multiple SoberLink violations. Is that correct?
Correct.
And that we had properly requested another PEth test as court ordered, and mother had refused to take that, correct?
Correct.
And in fact, you had prepaid it in advance, correct?
Correct.
Right? And then there was another incident leading up to that where you saw her intoxicated in your presence, correct?
Correct.
Okay. So after that, as a result of that emergency motion, there was a hearing held March 16th of 2022 by the associate judge, and those rulings are reflected on petitioner's 5, correct?
Correct.
And the associate judge further restricted mother's visits to 2 hours of supervised visits only, correct?
Correct.
You were ordered to be solely in charge of Mason at that time, correct?
Yes, sir.
And you did the intake for the supervised visitation center, correct?
Yes.
But the supervised visitations never happened, did they?
No.
Okay. Mother was also ordered in the further emergency order to continue to use SoberLink, correct?
Correct.
And she actually stopped using it from that point altogether.
Yes, sir.
And she's been on a court order to use SoberLink throughout this case, and she stopped using it and has not resumed, correct?
Yes, sir.
And we also requested another PEth test, and she was ordered to take that, and she refused, correct?
Correct.
And again, you had paid for that in advance.
Yes, sir.
And mother was also ordered in the emergency hearing to attend individual counseling for alcohol abuse. And to our knowledge, she never did that, did she?
No, sir.
So basically, mother's had no periods of possession of Mason since approximately March of 2022, correct?
Correct.
Now, you have let her see him on a small number of occasions since then, correct?
Yes, sir.
Supervised by you, correct?
Yes, sir.
And does Mason express a lot of desire to see his younger brother?
Yes.
And he's worried about his younger brother, is he not?
Yes.
Okay. And there was one original drug test ordered of you at the very first temporary orders hearing, and you passed that, correct?
Yes, sir.
Since then, you've done some voluntary testing at my request, and those are on file with the court, correct?
Yes, sir.
And all those are marked as petitioners 10 through 13, correct?
Correct.
Okay. November 27th of 2023, we appeared before the associate judge who ordered a custody evaluation, correct?
Yes, sir.
You were ordered to pay, based on your income, $2,500, and you did pay that, correct?
Yes.
And Ms. Guile, based on her income at the time, was ordered to pay $840, correct?
Correct.
And she never paid that, did she?
Not that I'm aware of.
No. So we went back to court then in February of 2024, and as reflected on petitioners 2, obtained an order from Judge Lee ordering Family Court Services to proceed with the evaluation on you only since mother had failed to pay, correct?
Correct.
Okay, and that did happen. They did the evaluation of you only because mother didn't participate, correct?
Correct.
All right. And then we later went to mediation. That was not successful, and now we're in trial, correct?
This moment is pivotal. The forensic interview at the Child Advocacy Center. This isn't casual questioning. These are trained specialists interviewing children about potential abuse in a controlled, trauma-informed environment. The fact that CPS later found reason to believe sexual abuse occurred, that's one of the strongest determinations they can make short of criminal conviction.
Yes, sir.
Now, let's go back. You talked about these outcries by Mason. As a result of outcries of sexual abuse to you, you started him in therapy?
Yes, sir.
And later, did Mason make an outcry of sexual abuse to the counselor?
Yes, he did.
And as a result, did the counselor contact Child Protective Services?
Yes, sir.
And did they start an investigation along with the Colleyville Police Department?
Yes, sir.
And Colleyville's, because that's where you live, in Colleyville, correct?
Yes, sir.
on August the 5th of 2022, did you take Mason to the Child Advocacy Center in Tarrant County for a forensic interview?
Yes, sir.
And petitioner's 16 admitted into evidence is a summary of that forensic interview made by the Colleyville Police Department, correct?
Correct.
When you think this case couldn't spiral further, the father plays a FaceTime video showing the mom drunk and emotional just weeks before trial. In a custody hearing, that kind of live proof isn't just embarrassing, it's devastating. The judge doesn't need speculation anymore, she's seeing the pattern unfold in real time.
And that does indicate in the forensic interview of Mason that he made outcries of sexual abuse against him by his mother, correct?
Correct.
And Mason was highly concerned that the same thing was going to happen to his younger brother, correct?
Correct.
And that was investigated by CPS Tarrant County and Colleyville Police, but Tarrant County couldn't prosecute because those offenses had not occurred in Tarrant County, correct?
Correct.
Okay. CPS wrapped up its investigation, was reflected in petitioner's 15 with a finding of reason to believe sexual abuse committed by mother against Mason, correct?
Correct.
And then you've continued to take him as needed to a therapist, correct?
Correct.
And he's now at the point where the therapist says you can bring him as needed. He may need it later as he goes through puberty and starts to age, correct?
Correct.
Okay. I want to fast forward now I want you to think about a month ago, September 7th of this year, just a little over a month before this trial, about 9 p.m. at night. Did Ms. Guile contact you by FaceTime video conferencing?
Yes, sir.
And did you record that FaceTime video conference?
Yes, sir.
And that's reflected on our exhibits 38 and 39, correct?
Yes.
And is she clearly intoxicated in that video?
Yes.
Is she start out laughing and giggling and being silly and then suddenly become highly emotional and start crying?
Yes, sir.
Okay. And then shortly after that, is there a verbal altercation between her and the man who apparently she's living with at this time?
Yes.
And does he say to her on that video, you're not in your right mind, you need to go to bed?
Yes.
Okay. And is there a baby present who begins crying?
Yes.
So to your knowledge, since we did the original order, Ms. Giles had another child with somebody, and then she's had now a third child with another man, the third man, correct?
Correct.
All right. In the felony DWI case in Denton County, the indictment has been admitted as petitioner's 26. And you're aware she had bond conditions from June of 2022 prohibiting her from consuming alcohol or controlled substances, correct?
Yes, sir.
And there's a petitioner's 33 indicates that in August of 2023, mother tested positive as a violation of her bond for cocaine, methamphetamine, amphetamine, and alcohol, correct?
That's what I understand. Yes.
Right, and that ultimately she pled guilty to the DWI felony as on probation, correct?
Correct.
Finally, we have photographs from mother's Instagram account, petitioner's 35, showing the Miami trip in January of 2023 with Girls' Night Out, showing her drinking what appears to be an alcoholic beverage in front of her, correct?
Correct.
Then we have another picture from her photos, petitioner's 36, dated February of 2024, showing a private jet and her in Las Vegas for the Super Bowl, correct?
Yes.
And the title of it is Life Has Been Extra Special Lately, correct?
Correct.
She has designer clothes on, including a designer purse, correct?
Correct.
And then finally, petitioner 37, a reflection of mother from her Instagram of her Mexico Beach trip in June of 2025, correct? Is that correct?
Yes. Yes, correct.
Okay, and she has claimed to Judge Lee in the past that she didn't have the money to do the custody evaluation, correct?
Yes, sir.
Or the sober link, correct?
Yes.
This closing exchange shows the human side. Despite everything, the addiction, the CPS reports, the failed tests, the father's focus stays on the child's progress. He's doing well in school. He's thriving. It's a bittersweet victory, proof that stability changes. Everything
The exhibits P21 through 25, those all relate to attorney's fees, and you're asking the court to award attorney's fees, correct?
Correct.
All right. And you have health and dental insurance, and you cover Mason, and that's on petitioner's 20, correct?
Correct.
In summary, how's Mason doing now?
He's doing great. He's thriving in school. He's got friends. He's above average on his. He's got a MAT test in his for his third grade, and he's in 200, I think 219 and 208, which is well above average. So he's doing great.
Okay. And do you believe all of the orders we've requested about you being sole, mother not having any access or possession at this time, are all necessary for the safety and welfare of Mason at this time?
This case shows how family court doesn't just weigh evidence, it weighs responsibility. Sobriety, safety, and truth all collide here. And in the end, it's not about punishment, it's about protection.